Honorable Attorney General.
Mr. Speaker, I beg to move the following motion standing in my name. Be it resolved that the Senate amendments to the Administration of Justice, Indictable Proceedings Amendment Bill 2025, listed in the appendix, be now considered. Now, Mr. Speaker.
The question is that the Senate amendments to the Administration of Justice Indictable Proceedings Amendment Bill 2025 listed in the appendix be now considered. All in favor say aye. Aye. Any against? The ayes have it. Honorable Attorney General. It is for the clerk to read the First Amendment.
Long title, inserting after the words 2011, the words, and to make consequential amendments to the Bail Act, Chapter 460, and for other related matters.
Honorable Attorney General.
Mr. Speaker, the act was passed in this place on the 10th of September, 10th of October, 2025. 4 days later, a decision of the High Court held the attempt to amend the AJIPA in 2023 by my colleagues opposite to be unconstitutional insofar as it took away the power of JPs to grant station bail in indictable offenses. The legislation was amended. We moved with alacrity to amend the legislation before it got to the Senate to take into account that decision, which we considered to be proper and which we considered to align with the policy that we had advocated in respect of search warrants. That is to say, to grant JPs the powers which they have had for the last 120 odd years. I beg to move that amendment be approved.
Honorable members, the question is that this House agree with the Senate in the amendment to the long title of the Administration of Justice Indictable Proceedings Act 2025.
I beg to move.
I looked on, no one stood up. No one stood up. No one stood up. Right, so we're going to move on. Everyone has to move with alacrity now. Honorable Attorney General.
Wake up, man, wake up.
The question is that this House agree with the Senate in the amendment to the long title of the Administration of Justice Indictable Proceedings Amendment Bill 2025. All in favor say aye. Aye. Any against? The ayes have it.
Clause 1. Delete and substitute the following clause, short title and commencement 1, subsection 1. This act may be cited as the Administration of Justice Indictable Proceedings Amendment Act 2025. 2. This act comes into operation on such date as is fixed by the President by proclamation.
Honorable Attorney General.
Mr. Speaker, we inserted a proclamation clause in the Act in the Senate on the promptings of the independent senators. A concern was raised that one, justices of the peace needed to be trained. We accepted that because it aligned with a statement made by the line minister, the Minister of Legal Affairs, who stopped short of giving a commitment to do that training, but recognized that it was necessary. We felt that the training was necessary, the Senate felt that the training was necessary, insofar as the power to issue search warrants was concerned. So we stuck in a proclamation clause to treat with that part of the legislation. Of course, the bail bit, we intend to to proclaim that right away. I beg to move.
Honourable members, the question is that this House agree with the Senate in the amendment to Clause 1 of the Administration of Justice Indictable Proceedings, Amendment Bill 2025. Vote to Spain South.
Mr. Speaker, thank you for acknowledging me. And maybe this was the appropriate time to stand up in the first place. The amendment that is being sought, Mr. Speaker, we are unable to agree with it because, Mr. Speaker, what is happening here is that the powers being bestowed upon the justices of the peace as it relates to warrants in particular, not so much bail, but as it relates to warrants, without the prerequisite training that goes before that, Mr. Speaker, is something that is of serious concern to this side. Mr. Speaker, what happens, and the Honourable Attorney General has not addressed it, is that a justice of the peace will continue to hold concurrent authority with a master, but of greater constitutional importance is that it gives a master and the justice of the peace concurrent powers that will expand the power of a justice of the peace, even though it's one warrant he can issue, to issue warrants in circumstances where there is no such training. Mr. Speaker, it empowers a justice of the peace to issue one warrant in the most intrusive of manners on people's private constitutional rights, with no safeguard being in place. And in this regard, this side has a serious concern about it, in that you give the power without doing the training. And Mr. Speaker, it is not correct to say, because I heard it said in this House that, well, justice of the peace for 2,000 years have been issuing warrants. That was before the Magna Carta, that was before the Constitution. We have a Constitution in Trinidad and Tobago, and on this side, we would like to abide by the Constitution.
Honourable Attorney General.
Mr. Speaker, I'm not sure if my colleague and friend heard me, but in respect of bail, that aspect of the matter, the bill was amended in the other place to include bail. We moved quickly on this side. So when it was before this House, it dealt only with search warrants. But by the time it got up to the other place, there was a decision, and we codified that decision. Nobody in the other place had a problem with that. Okay, so nobody in the other place had a problem with the JPs granting bail. We stuck in the proclamation clause to say, listen, let us go forward with bail right away, on which we have absolutely no agreement, no disagreement. We have disagreement on search warrants. The disagreement in the other place, the majority of the members said, train the JPs. And we said, okay, we do that. The minister had made that commitment here. So that I'm not understanding the problem. We stand by our position. I beg to move.
Honourable members, the question is that this House agree with the Senate in the amendment to clause, it's one, right, Charlotte? Clause 1 of the Administration of Justice Indictable Proceedings Amendment Bill 2025. All in favor say aye. Aye. Any against? The ayes have it. Okay. Advised that in accordance with Standing Order 126, there has been agreement between both sides to take the clauses 3 and 5, clause 3 and new clause 5 together.
Clause 3A. Delete paragraph A and substitute the following paragraph. A. By repealing subsection 1A and substituting the following subsection. 1A. Subject to subsection 1B, for the purpose of this Act, a magistrate, a magistracy registrar, and clerk of the court, or a justice of a peace shall not have nor exercise jurisdiction in relation to any matter, A, referred to in subsection 1, or B, for which a master is given jurisdiction under this Act. B. Delete paragraph B and substitute the following paragraph. B. By inserting after subsection 1A the following subsections. 1B. For the purpose of this Act, A magistrate, a magistracy registrar, and clerk of the court, or a justice of the peace shall, subject to subsections 1C and 2, have and exercise concurrent jurisdiction with masters to issue search warrants, and B, except where an accused is required to show sufficient cause or exceptional circumstances under section 5(2), 3, or 4 of the Bail Act, a justice of the peace shall, subject to subsection 3, have and exercise concurrent jurisdiction with masters to grant bail in accordance with section 5(2) of that Act, to fix the amount thereof and take recognizances. 1C. A justice of the peace shall not A. Issue a search warrant in respect of more than one set of premises at a time, or B. Exercise jurisdiction under section 5(1)(b). C. In paragraph C, delete the full stop and substitute the words semicolon and. D. Insert after paragraph C the following paragraph. D. By repealing subsection 3 and substituting the following subsection. 3. Where A. The registrar grants an accused bail or remands him in custody, he shall cause the accused to appear or be brought before a master and shall transmit the record of the proceedings and all relevant evidence to the master. Or B. A justice of the peace grants an accused bail, he shall cause the accused to appear or be brought before a master. New clause 5 inserted. Insert after clause 4 the following clause. Consequential amendment to chapter 460, Act number 20 of 2011. The Bail Act is in subsection 5, in section 5(2), pardon, I'm just going to read that again. Consequential amendment, chapter 460, Act number 20 of 2011. 5. The Bail Act is amended in section 5(2) by inserting after the words subject to the words section 10 of the Administration of Justice Indictable Proceedings Act 2011 and.
General.
Mr. Speaker, in the other place, there was a concern that in giving the justices of the peace the powers which they had since 1916, between 1916 and 2023, and particularly power to grant station bail in respect of indictable offenses, that we had, in an attempt to do that, we had unwittingly, because this was an AJIPA matter, we had allowed them, the powers under AJIPA to deal with multiple premises at multiple times. The amendment takes care of that, and that's the reason for the amendment. It was made by one of the senators in the other place who has considerable experience in this area. I thought it had merit, and we've accordingly made the amendment. I beg to move.
Members, the question is that this House agree with the Senate in the amendments to clauses 3 and 5 of the Administration of Justice Indictable Proceedings Amendment Bill 2025. For the Spain South.
Precisely the mischief that this side has a disquiet about is what is being discussed here. Now, apparently what came from the upper house was, look, the justices of the peace, you don't give them the power to issue several warrants, but they get the power, Mr. Speaker, to issue a warrant for one set of premises. What precludes the same justice of the peace without the safeguards to be in place first for issuing one warrant for one set of premises, another warrant for the other set of premises? The mischief is not cured by that, Mr. Speaker, because here's the mischief. What the substituted Section 1A makes it plain is that magistrates, magistracy registrars, justices of the peace shall not exercise jurisdiction in indictable matters reserved for masters under subsection 1. We can have no complaint with that. But that limitation is immediately eroded when you look at the new 1B, because it expressly restores and preserves the concurrent jurisdiction of a justice of the peace in two critical areas. We have no issue with the bail, because that is something that Justice Gobin dealt with in the Alexander case, and it's a practical consideration, because when the court is closed, people want to get their bail. But when it relates to the issuing of warrants, Mr. Speaker, we have no systems in place in Trinidad and Tobago, for example, to verify whose names are gazetted, which justice of the peace names are gazetted. There's no systematic vetting of their suitability, no mechanism to report incapacity, no mechanism to report misconduct, no mechanism for a disciplinary framework that reflects the gravity of the powers that we are now bestowing on them. To say, well, you don't have the power to issue several warrants, but you have the power to issue one warrant at a time, still gives them the power to issue warrant for serious matters, Mr. Speaker. And say removing multiple warrants and putting it to one still does not cure that concern that we have. So, Mr. Speaker, the opposition is compelled to put on record its concerns about the legality, the accountability, the transparency, and the protection of the rights enshrined in the Constitution, the backdrop of giving, we have no issues with the justice of the peace, but giving them that power. And that has been our concern when the bill had its first incarnation here and remained consistent. That is our concern now. Mr. Speaker, the opposition cannot endorse amendments that place greater authority in the hands of unregulated and structurally weak system, that is the justice of the peace system in Trinidad and Tobago, and for these reasons, we must be reluctant to support it. Thank you.
Honorable Attorney General.
Mr. Speaker, the section reads, a justice of the peace shall not issue a search warrant in respect of more than one set of premises at a time. And then it goes on, exercise jurisdiction under section 5, large I1, large IB. We think that that captures the sentiment in the other place. It's consistent with government policy, which is to give to justices of the peace a proper role in the justice system. In terms of training, we have undertaken to do that, and Mr. Speaker, with those words, I beg to move.
Honorable members, the question is that this House agree with the Senate in the amendment to Clause 3 and the addition to Clause 5 of the Administration of Justice Indictable Proceedings Amendment Bill 2025. All in favor say aye. Aye. Any against? The ayes have it.